Hello and welcome to LiveLaw Academy. In this session, we will understand few things regarding cancellation of bail. But the most important question that we are going to answer in this session is whether the trial court can cancel the bail which was granted by a constitutional court, and for that matter, by a superior court. Can the trial court cancel a bail granted by a superior court? But in this session, we will discuss what is meant by cancellation of bail, who can apply for such cancellation, what are the grounds for cancellation of bail. We will briefly touch on these questions and then we will arrive at the main issue whether trial court can cancel the bail granted by a constitutional court. So the first question before us is what is meant by cancellation of bail. You see, the term cancellation of bail is not defined in CRPC and BNSS. But in practice, it means that you are sending a person to custody again who was earlier granted a bail. Right? Here, the intention or the purpose is not punitive. The objective is not to punish the person, but to ensure that the integrity of the entire uh, criminal procedure, it remains intact. It does not suffer. So for something which is done after the grant of bail, that is considered, and since that thing has an impact on the overall integrity of the system, hence the person will be sent to custody, his liberty will be taken back, which was earlier recognized and granted through bail. Right? That is the meaning of cancellation of bail. Now, who can apply for cancellation of bail? Number one, the state or the prosecution can apply. Number two, the victim, the aggrieved party, the aggrieved person can also apply for cancellation of bail. Third circumstance is the High Court can itself cancel the bail by invoking inherent powers. That is also permissible. It has in High Court has inherent powers under the CRPC as well as BNSS. Now, interestingly, number fourth is that any citizen, any person who is public spirited can also apply for cancellation of bail, can also bring the circumstances before the court on which the bail can be cancelled. And this was held in the case of Ratinam versus State, AIR 2000 Supreme Court 1851. Ratinam versus State, AIR 2000 Supreme Court 1851. In this case, it was held that any public spirited person, any person who's concerned with the public interest can also bring such circumstances before the court which warrant cancellation of bail, which require the bail to be cancelled. Right? Now, what are the grounds for cancellation of bail? Let me just briefly discuss those grounds. See, the approach of the courts in case of cancellation of bail is this, that they will be very cautious. They will not allow such an application. They will not order cancellation of bail very readily, because ultimately it is a matter of liberty, right? And in cases of liberty, you have to be very cautious. So in cancelling the bail which is already granted, the court will tread very cautiously. And in Daulat Ram versus State of Haryana, 1995, Volume 1 SEC 349, in this case, it was held that bail shall be cancelled in the event of, in certain supervening circumstances. Now, what are those supervening circumstances? Number one, when the bail conditions are violated. Number two, when there is abscondence or an attempt to flee away from justice. Number three, when witnesses are threatened. Number four, when evidence is tempered. And if any similar offense or any other unlawful activity is done when the bail was granted, after the bail was granted, all these circumstances, they're not exhaustive circumstances, there can be other circumstances. All these circumstances indicate that bail can be cancelled and should be cancelled in such situations, because now you're just abusing the process of the court, you're abusing the liberty which was granted to you by bail, right? So that such an abuse will never be permitted by the law, right? Now we come at the heart of this discussion, and that is, can the trial court cancel the bail granted by a constitutional court or a superior court for that matter, right? Now, intuitively, the answer to this question seems to be a no. But the law, as clarified by the Supreme Court, says that yes, it can be done in certain situations, in certain circumstances. And recently, it was done in the case of, it was again recognized in the case of this MLA and minister from Karnataka, former MLA and minister from Karnataka, Vinay Kulkarni, right? Vinay Kulkarni was granted bail by the Supreme Court in a murder case. Later on, the CBI alleged that he was tampering with the witnesses, and they made an application before the trial court for cancellation of the bail. The trial court said that it can't interfere because the bail was granted by the Supreme Court. Now, when the matter again came back before the Supreme Court clarified that when a superior court grants bail and authorizes the trial court to impose or enforce the conditions, then in such cases, bail can be cancelled by the trial court itself in case of violation of such conditions. That is the law. That is the position of law. And this position of law, this proposition is rooted in a landmark judgment of 1978. You can note down the decision, Gurcharan Singh versus State, Delhi Administration. Gurcharan Singh versus State, 1978, Volume 1, SCC, 118. 1978, Volume 1, SCC, 118. Another example of trial court cancelling the bail, the law on this, is the case of P.K. Shaji versus State of Kerala, AIR 2006 Supreme Court, 100. AIR 2006 Supreme Court, 100. In this case, the bail was granted by the Court of Session with the direction that the trial court can enforce the conditions. In case of violation of those conditions, it was the trial court which cancelled the bail, and the Supreme Court upheld it. Right? I will read the exact para for you. The words of the Honorable Supreme Court from this case. The Supreme Court upheld it by stating that the Superior Court can always give directions and authorize the subordinate court to pass appropriate orders, and the trial magistrate would be the competent authority to decide whether any condition had been violated by the person who had been released on bail. And in such a situation, In case of violation, if the violation is found, the bail can be cancelled. Right? Now, I hope that this session brought clarity on this particular issue. And please subscribe to this channel so that you do not miss any such discussions from LiveLaw Academy. Thank you for joining me today. And I always seek your suggestions in the comments as to what topic is to be covered. For example, the last time there was a request that um, various stages of suits and applications that can be made at each stage. There should be a video on it. So we work on it. If like that, if you have any suggestions for us, do mention them in the chat box, in the comment box. Thank you. Take care. Good evening and happy weekend.